Hi everyone, I am Surenraj and my matrix number is 201872 and this
I am Adli and my metric number is 200 for Edward.
today we are going to present a case study analysis regarding trademark.
First, we can start with the question, what is trademark?
A trademark is a way for a business to help people to identify the products that the business makes from products made by another business. A trademark can be a name, word, symbol, logo, design, or a picture. It can be only used on things made by the business that owns the trademark.
We have decided to present a case between Samsung Electronic Company Limited and Orient Company Limited regarding the trademark issue. Let's get started.
This case study is an application to remove a trademark from the register of trademarks. The plaintiff, Samsung Electronics, is the creator of Galaxy and Samsung Galaxy trademarks. They first applied to register the trademark in South Korea in March 2010. The first trademark application by plaintiff applied on 1st July 2010 for Samsung Galaxy Tab. The application also included Samsung's other lineup of smartphones and portable computers under Class 9.
The plaintiff launched its Samsung Galaxy Watch in Malaysia on the 1st of October 2018. They filed a trademark application for the Samsung Galaxy Watch on 20th of September 2018. After that, plaintiff received a cease and desist letter dated 28th of September 2018 from the defendant's Korean solicitors, claiming that the defendant is the proprietor of the Galaxy trademark for watches in Class 14.
After receiving the cease and desist, the plaintiff accordingly searched for register of trademarks and found that there was a registered Galaxy trademark in Class 14 in the name of the defendant dated 12 July 1990. There's also another application by the defendant for registration that is still pending for Galaxy trademark dated 30th August 2010, also in Class 14.
Following that, the plaintiff searched for the evidence of sales for defendant Galaxy Watch in Malaysia and also hired an investigation agency, Ceras Corporation Sendirian Berhad, to make sure the usage of defendant's mark in Malaysia as they claimed before.
After the investigation, the plaintiff filed an application which declared the trademark registered by the defendant in the register of trademark is an entry made without sufficient cause or an entry wrongfully remaining in the register. Hence, it should be removed from the register of trademarks. Any costs related to this process will be paid by the defendant. As by now we can understand that the trademark was registered without an intention in good faith means the registered trademark is not being used properly by the defendant. If it has not been used in good faith for a continuous period of 3 years, especially in a counterclaim to trademark infringement action, the defendant's mark can be expunged or removed from the register.
In this case, the plaintiff, Samsung Electronics, clearly states that there is genuine use of the Galaxy trademark for themselves. If the mark is put to real commercial use on a substantial scale, they have been using this Galaxy trademark since 2010 for real commercial use. At the same time, the defendant lacks of evidence for sales of its own products, and they also failed to build a good faith on defendant's mark. Hence, the trademark registered by the defendant is not being used in good faith.
According to the article, which is published on issue 120 of the Intellectual Property Forum, Journal of the Intellectual Property Society of Australia and New Zealand Incorporated, no intention to use goods and services covered by a trademark registration may constitute bad faith, which means if a third party is using the same trademark for commercial use and building a good faith, the situation might favor them. Your trademark could be expunged or removed from the register of trademarks if there are sufficient evidence for that claim.
Consequently, the plaintiff has to establish that it is an aggrieved party and there has been no use in good faith of the trademark in relation to those goods or services by the defendant for the time being up to date 1 month before the date of the application. A person aggrieved is a person who has used his mark as a trademark or who has genuine present intention to use his mark as a trademark. In the course of a trade which is the same or similar to trade of honor of the registered trademark that the person wants to have removed from the register. Thus, a person aggrieved may have no rights at all, but merely a genuine intention to use the trademark that is registered but which has not been used by the registered proprietor.
In this case, it is evident that the plaintiff is an aggrieved party, and the court is satisfied from the plaintiff's affidavit in support of the plaintiff is the bona fide proprietor of Samsung Galaxy marks, and a few other variants of thereto of goods falling in Class 9. The plaintiff has furthermore filed a trademark application in Malaysia for the Samsung Galaxy Tab mark on 1st July 2010 in Class 9. The plaintiff also filed a trademark application in Malaysia for the Samsung Galaxy Watch mark on 20th September 2018 while claiming priority of the US trademark application dated 4th May 2018 for goods falling in Class 9. Accordingly, the plaintiff has also intensively as well extensively promoted in Malaysia goods that carry the Samsung Galaxy Tab mark and later the Galaxy Watch mark.
The plaintiff has also contended that defendant has not used the defendant's mark for at least 3 years between 19th of November 2015 and 19th of November 2018, which is the material period for purposes of this application. From the evidence adduced by the plaintiff, the internet search of the defendant's corporate information on sales record for the period of 2014 to 2018 showed no sales record for watches abroad, and the internet Google search on Galaxy Watch revealed only association with plaintiff in Malaysia. The investigation report of Cheras Corporation Surenraj A dated on 19th of November 2018, commissioned by the plaintiff on random survey of 10 watch retail shops throughout Malaysia, confirmed that products in Class 14 bearing the defendant's mark are never sold by them. Most of the sellers are in fact not even aware of the products bearing the defendant's mark.
To conclude this case, Judge Lim Chong Fong found that there has been none used in good faith by the defendant of the defendant's mark in Malaysia for at least for a continuous period of 3 years up to 1 month before the date of application on 20th December 2018. Hence, he ordered that the defendant's mark should be removed from the register of trademarks.
In our opinion, the judge has given a fair verdict, which is to remove the defendant's mark from the register. We can understand that if a party is owning a trademark, they must use it for commercial use.
Just owning the trademark and not using it may cause a bad faith and will make other parties who are using the trademark to have an upper hand on this situation.
Okay, that's it from us. Hope you all enjoyed our content and have a better view regarding the trademark issue. Thank you.
See ya!